search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
Stop with that.
Right out of the gate, the judge shuts down emotional appeals. This is huge. In sentencing, courts focus on actions, not excuses. But let me ask you, should family circumstances ever matter in a case like this? Or is the judge right to ignore it completely?
Everybody else, because I'm not going to make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. Sanders, and Ms. Sanders was previously here in cause number 22-39884, entered pleas of true to counts 2 and 3 and a motion to revoke community supervision. I received an updated pre-sentence report. We're here for a sentencing hearing. Has everyone had an opportunity to review that report?
Yes, Judge.
Are there any additions or corrections to the report?
Your Honor, my concern, I guess I can address this after Mr. Smith had the opportunity to present evidence on the new offense, was that the recommendation appeared to be predicated on an assumption that the new offense had been proved up, and that was going to be my issue with the pre-sentence report. Of course, if Mr. Smith is prepared to prove it up, then
okay, let's go through that.
The necessity for me to go into that.
All right, we'll go through that first, and it's my understanding, and we spoke earlier, kind of off the record, that the officer involved is unavailable, but that Mr. Smith has his body cam video footage from that date, and there's no objection to him putting that on as evidence in this hearing. Is that correct, Mr. Kimler?
Yes, Your Honor, that's correct. My understanding is due to the exigencies of the officer being involved in the shooting, he's on administrative leave and is unavailable to testify. I therefore don't have any objection to the body cam being played in his absence.
Thank you, Mr. Kimler. And just let me know when you're ready, Mr. Smith. And Ms. Lopez is here. Thank you, Ms. Lopez. And at the appropriate time, if you have anything to add as well, I'll give you an opportunity to do that. And so the allegation in count 1 that was not pled true to or not is the allegation of a new theft of property from July 31st of 2025 here in Jefferson County.
He's got to play the video.
Patrol 115-82 cars.
Hey, stop. You're being detained? Man in the back, please come up here. Hey, you're being detained, okay? Okay, we'll worry about that in a second. Just come over here so we can talk. Okay, so you're not under arrest, you're just detained. And so, hey, put your hand behind your back. I thought she was detained right now. She just took everything out and dumped it on the floor back there. Put your hands behind your back. Wait for everything.
Once already.
And just stay here.
I was
Do you have any other merchandise on your person? Anything illegal underneath you?
like the case right here at the top.
They can take this. I gotta walk out the store.
Yeah, we did. I watched you on the camera.
What?
I've been watching you on the entire time.
Okay. What we're doing, look, if you have anything illegal, look at me. Hey, just look at me. If you have anything that you didn't buy, stand on the counter.
Can you text this out to me?
Not at the moment, no, because
I'm talking about.
the way you're acting like a fool.
Oh no, I'm not gonna do that.
You act
Still,
like a
I
fool.
promise I'm not.
Just like so, just put it all right here. Nothing else in your
No,
pants or anything?
no.
All right, let me.
All right, any other?
This is where it gets legally interesting. The defense hints at an illegal search, but notice what actually happened. She voluntarily handed over the items. That often kills a Fourth Amendment argument. So here's the question. Was this truly voluntary or subtle pressure from police?
Evidence with regard to count one?
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you had told her not to do this anymore. But I think that first video kind of sums everything up.
All right, any evidence with regard to count one before I make my finding?
Evidence, Your Honor, as in testimony?
And anything that could,
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
they didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and so,
Followed the direction. And there's
Yeah.
no Miranda issue since she wasn't
right.
arguably in custody. I don't have any argument. I will go ahead and object that that's an illegal search.
All right, that objection's overruled. I am going to find count one true. And so, let me see, I need to. Counts 2 and 3, she pled true to, so there's a finding of true. Count 2, again, everyone's had an opportunity to review that pre-sentence report. Mr. Kemmler, you may make argument with regard to
Yes, Your
punishment.
Honor. At this stage now that the state has offered evidence as to count, as to the new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would, again, defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose, I don't know if it's the next word.
With the pending charge of this theft, she's not eligible to go to ISF.
She's, if I may, she's set on that today. I can resolve that today in this.
No, it's pending in felony.
It's here,
Oh,
it's
is it here?
mine.
Okay.
Because of the prior
All right.
thefts.
All right,
She's done with misdemeanor
right.
thefts.
We could resolve that perhaps today, Your Honor, if the court.
I mean, I'm, go ahead.
The
What was
state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to the state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated report?
Everything in my recommendation.
All right.
Do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've ever been away from my kids besides when I did 8 months, but they was younger than me, and like I was younger, and like they understand what's going on. And I understand, and like me being away from my kids right now is really hard. Cause they be with my mama, and my mama had dementia. And she,
Stop with everybody else, because I'm not going to make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me,
No, I'm-
that if I send you to prison,
Don't talk.
that I'm somehow going to be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was going to happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again, and you did it again, it just makes me look like an idiot.
That line, "You make me look like an idiot," that's pure courtroom frustration. This is what happens when second chances get burned. Judges remember patterns. So tell me, was this justice finally catching up? Or should she have been given one last chance?
For giving you the opportunity in the first place. At some point, you have to stop. At some point, you have to stop. Anything else?
Judge, even based on what she told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation,
Right.
wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
accept responsibility.
how is this my responsibility?
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm gonna tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, if you're in there doing it, you are the wrong person, right?
Yes, ma'am.
So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to,
I'll get the other one worked out today.
okay, I'll hold it while y'all do that, and then while I'm doing that, I need I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way. Good morning, are you Braxton Hughes? And this is 25 DCCR 1124. Mr. Hughes was previously in court, entered a plea of guilty to burglary of a habitation. The agreement was for a cap of 4 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
None aware, Judge.
Obviously, I'm aware of some of his criminal history, others not quite so much. I would think that the 4 would probably be on the low end in your opinion, but I defer to whatever you think.
Okay, thank you. Mr. Parker, you may proceed.
Your Honor, I mean, I've talked to him and I've heard some stories in my life, but I feel that he's telling the truth, not that it's a defense, but they were getting pulled over. He had some other guys in the car. There was drugs in the car. They took the drugs. He leaves and goes to a house that he used to know the person that lived there. He walks in, gets him something to drink and has a thermos or something like that, and then turns around and she stayed in there. He had obviously scared her and didn't know it, and it wasn't the person he knew that lived there. And he said, call the cop, and he walked outside and sat down and waited for the cop to show up. And that's what happened. It's not like he was going in there, to try to injure her. I don't think. He walked in the wrong house, and he did take the thermos or mug, and it's simple as that. I think he'd like to talk to the court, Judge, and we're asking for probation, Judge.
All right, go ahead, Mr. Hughes.
Your Honor, what he said is correct. I can't say anything else. I was doing drugs about 1.5 years, and I was like a lightweight. I took the drugs and was not really acting like myself. And I went and knocked on the door and went in there. I was trying to get away from the people I was with. And but long story short, after this event, I did sober up. Started going back to church with my mom. I was in for treatment at the Right Step. I tried to get into treatment there. I was doing the paperwork, trying to get help, but I was sober for a couple months out there on the streets, and I'm not really like a typical druggie type. I don't go around and commit crimes or nothing like that.
Your criminal history would say otherwise.
This has been a long time.
I understand, but be careful how you word things because you've been a criminal since 2002. You've got 4 misdemeanors. You've got 1, 2, 3, 4, 5 felonies. Many more that you were arrested for, and obviously doing some things that you kind of got either rejected or dismissed because of pleas on other stuff. So I understand that some of those were a long time ago, but it's still not a pretty picture.
I understand that. Most of my previous crimes and stuff, they were behind addiction and stuff. But life's a journey, and I haven't. I still was battling with addiction, but not committing crimes. This, I know, with the standing here in front of you, charged with a crime, I could understand, how the time.
Yeah, and it's at what point do you go get that help before you commit a crime? I do appreciate what you've done since the offense, Ms. Maltino.
Judge, I would definitely agree that this is an odd fact pattern, very odd. I feel sorry for the situation that he's in with his addiction, but I feel more sorry for the young lady who was scared out of her mind when he was in her house, acting probably like a complete psychotic animal with tinfoil on his head. So I don't know that probation at this juncture would be a viable option, Judge, or a good thing for the community, but I defer to whatever you think is best.
If your history had, one of the things that is sticking out is that every probation you've ever gotten has been revoked. So you've never been successful on probation. And so,
Completing the last one.
huh?
I did complete the last one.
The last one that I see was the federal
Yes, ma'am.
sentence where your supervised release got revoked.
I did get revocation, but I got back out on probation and completed it.
Okay. At this time, Mr. Hughes, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff.